This is the Money Hour with your host, Tina Mitchell, on Alternative Talk, AM 1150. Now, back to the show with local mortgage and finance expert, Tina Mitchell.
Welcome back to the Money Hour with your host and mortgage expert, Tina Mitchell, right here at 1150 AM KKNW, the Saturday, August 8th show, bringing in expert advice and inside knowledge on today's events in our local economy and how they can affect your money. If you're hearing my show at a different time or day, you are listening to a rebroadcast, but you can always call the show at 1-855-400-1150. Again, that's 1-855-400-1150, or online at themoneyhour.com to ask any questions or be connected with the guests that I have in studio today. And right now, we're going to be talking with Anton Cauthorn with Rehberg Law Group, estate planning tips if you own real estate. Anton, thank you so much for coming back in studio. Excited to talk to you about estate planning. Is one of those things that, well, there's a lot of things we do in our financial arena that we procrastinate, but I think estate planning is one of the big ones. So it's always a pleasure to have you here and talk about how my listeners can be safe and make sure that their estate is set up. So a little background about Anton. Anton's been practicing in the arena of estate planning and tax for 4 years and holds a Juris Doctor degree from the University of San Diego School and Law, where he graduated with honors and was a lead articles editor for the San Diego Law Review. In addition, Anton has a members of law degree in the arena of tax law with a focus on estate planning and small business planning. Anton is a member of the Washington State Bar Estate and Gift Tax Committee and Q Law. Anton practice focuses on estate planning, estate tax planning, small business planning, and works with couples in non-traditional relationships and special needs planning. So talking today about the mistakes that can be made if you own real estate when talking about your estate planning. So what should you look for, Anton, for when your spouse passes away and you own real estate?
Thanks, Tina. This is one of the most common mistakes we see with real estate and doing estate planning. And there's a little myth out there that because Washington is a community property state, which means anything you purchase during marriage is going to be considered community property, that if your home is community property, then when you pass away, it automatically goes to your spouse. Mm-hmm. So a very common thing for us to see is somebody comes in, gives us a ring and says, well, I'm trying to sell my house and my spouse passed away 10 years ago, but now the title company is telling me I don't have clear title on the home. What do I need to do? Well, the mistake here was there wasn't a probate. There wasn't anything done when the first spouse passed away to transfer title to the surviving spouse. And that's one of the big myths. Even though it's a community property state, you still have to do something when one spouse passes away to transfer title to the surviving spouse. Otherwise, you end up in that situation where when you go to sell the home, normally about a week ahead of time, the title company finally does that title search, and you find out you can't sell, and now you have to go through your probate, and there's no way that's getting done within a week.
Wow, what a nightmare. I mean, it really is about the planning and understanding how you need to set things up. Now, Anton, what about owning real estate in multiple states?
Yeah, this is another problem that people often don't realize is a problem. So here in Washington, most winters are pretty bad and dreary, though this one wasn't too bad. But because of that, we have quite a few people who either, you call it snowbirding or sunbirding. They buy a piece of property down in California, Arizona, and they now have property in multiple states. Well, the issue is when somebody passes away, you have to go through a probate process in every state where you own real estate. So that means now you've got Washington, you have California or Arizona, and you're doing multiple probates. So what you've done now is created a mess for when you're gone for your beneficiaries, is maybe your children now have to settle probates in multiple states. Now, Washington's probates aren't that horrible. They're fairly simple. They're still complicated, but other states have even worse ones. California is one of the bad ones. So a probate in California can be very, very expensive. Mm-hmm. If you own a $500,000 piece of property, even if you have a $400,000 loan on that property, the value of the probate, the cost for the attorney's fees, is based off the value of the property without taking into account that loan.
Wow.
So you can end up with about $26,000 of probate fees with a $500,000 property. So it can be pretty complicated even in those situations.
So how do you fix that?
Well, the best way to fix this is by getting a living trust. It's the primary tool people use to avoid this probate problem in multiple states. So what they do is you get a living trust here in Washington, and then you transfer the property in California, the ownership, into your trust, or the property in Arizona into your trust. Now you can avoid the probate in every single state. And there's another way you can avoid these probates using something called a transfer on death deed. But not every state has these, and it's not always as clean of a tool. So the living trust is normally the preferred tool to avoid probate in multiple states. And
how do you advise that, Anton, when as a lender, they're not lending into trust?
Yeah, so there can be situations where a lender may say you can't transfer the property into the trust. And there's a number of things you can do in those situations. The transfer on death deed is one solution. So if the state allows the transfer on death deed, you can do that. Sometimes people will do something called a pocket deed. They'll draft the deed, sign it, but they won't actually file it with the court.
Okay.
And so there's a number of solutions to get around this, but it depends on the specific state and the specific lending agreement.
Makes total sense. Now, what about a child? Should you put your child as a co-signer on the home to avoid probate?
This is another common mistake, and this actually has quite a few mistakes in it that people don't realize they're doing. In this one, we often see someone comes in and says, oh, I just want to add my child onto the home because I want to avoid probate when I pass away. Well, I always tell them to stop and think about it because you have a number of things that can go wrong. First thing you may end up having is a gift tax problem. If you put your child's name on the home, you're actually gifting them a portion of your home. So if you own your home with your spouse, and now you add your child, you're giving them an interest in at least 1/3 of the property. So now they're a 1/3 owner. That means you have to file a gift tax return your next year with your income tax return. So that's the first mistake. Next, you've also now made your child an owner of the home. So what happens if your child goes out and gets in a divorce? They get in a lawsuit. Well, the attorneys in that divorce or the attorneys in that lawsuit, they look for every asset that your child owns. So now they come back and say, okay, they own a portion of your real estate. We're going to pull that in the lawsuit, and you may lose your home because of your child's liabilities. That can be a pretty huge problem if you're trying to just avoid probate.
Yeah.
Now you have a lawsuit. And
then on the lending side of it, that co-signer, they've got issues in for qualifying for other things possibly if the mortgage hasn't been made long enough. And what happens if somebody can't make the mortgage payment on time? Then that child is responsible for that. So that's other areas of problem. Now, what about vacation a home? There's so many opportunities you just talked about. I mean, opportunities of buying properties in other areas, and you want to leave that vacation home to your family. What do you advise your clients to do in that situation?
Yeah, if you have a vacation property or maybe a property that's been in the family for years and you want to make sure it stays in the family, the big issue is you want to make sure you plan ahead. We often see people do nothing, and then what ends up happening is the children have to work together to try to find some way to keep that property in the family. Maybe one of them's being difficult about it, so they're forced to sell. Maybe they can't figure out how to pay the taxes, pay the fees associated with the property, and so they're not able to keep the property. Or maybe they end up fighting over who gets to use the property when. Because there hasn't been any planning done ahead of time, you can create fights and create a problem where the property has to be sold. Now, the solution is you can use something called a vacation property trust or a dynasty trust, where you take the property, put it into a trust, and you set up the rules on how do they keep the property, who controls it, who makes the decisions on who gets to live there, how do they pay the taxes. By setting it up all ahead of time, you can set them up for success rather than failure to keep that property in the family for years and years down the road. Though that also brings up a second problem. We have kids who come in and say, my parents set up this vacation trust, and we didn't really want the property. What we really cared about was visiting our parents when they were there. We didn't like the place at all. It was just that our parents were there. So now we have to go in, take apart the trust that was set up. So the second mistake to make with vacation home property is to create a vacation trust without talking to your kids ahead of time to make sure they really want that trust.
Got it. So really planning out ahead of time to make sure that everything is set up and everybody's in agreement and what's going to work. And what their needs are. What about timeshares? There's a lot of timeshares out there, opportunities, people getting involved in timeshares with real estate. So is there anything special that they would do in regards to that?
Yeah, timeshares are a special issue because many timeshares are actually deeded real estate, just like your home. And if you remember what I talked about before, if you have property in multiple states, you may end up needing a probate in every state. So say you have a timeshare in Hawaii, timeshare in Florida, timeshare in California. Now you have 4 different states where you need a probate when you pass away. So this is another one of those situations. Plan ahead. Put together a trust so you can transfer all those properties into a single trust and avoid probate in every single state.
Wow.
Yep.
What about gifting property to your child to avoid estate taxes?
Yeah, one common thing we hear people say, I want to avoid estate taxes. I'm going to give my home to my child to avoid estate taxes. And the first question I ask is, how big is your estate? Because here in Washington, we have a $2 million estate tax exemption. If your estate is less than that, you're not going to have to pay estate taxes, which means you probably don't need to do gifting ahead of time. Second problem with this mistake is if you give away your home while you're alive to your child, that is now your child's home. If they decide to kick you out of it later on in life, they can do that. It's their home.
Wow.
So you're adding a lot of risk to your life and a lot of trust in your child for maybe minimal benefits of avoiding a $2 million exemption estate tax. So you want to be very careful and think about what you're doing before you gift that home to the child. There's also other tax implications for capital gains taxes. Normally, it's a bad capital gains tax consequence if you gift your home to your child, and you can actually end up paying more in capital gains taxes than they would have paid in estate taxes over the long run. So you want to make sure you talk to your estate planning attorney ahead of time before you go ahead and gift that property to your child to avoid the estate taxes.
Got it. Now, what about if you do have a living trust and you buy new real estate, you're adding to your real estate portfolio? What's your advice there?
Yeah, so if you buy a new piece of property,
because now there's a lot of buying a new pieces of property.
Yeah, so these days the real estate market is very good. So people are purchasing new pieces of property, and the mistake to make here is not putting that property into your living trust if you have one. Because again, if you have a living trust, but your home is not in that trust, or you buy that rental property you're talking about, it's not put in the trust, well, now you end up having to have a probate for that piece of property that's outside the trust. So the mistake here is make sure you title that property into the trust when you purchase it. Now, if you forget, you buy the property and it's in your name, it's not all lost. You can go back, talk to your estate planning attorney. They can help you make that transfer, but it's easier if you do it right up front when you're buying the property. Make sure the name of the property is the name of your trust. Got
it. So, Anton, any other common things that you see in mistakes that people are making that you can share with my listeners?
Yeah, there's a number of other mistakes, but really one of the biggest ones we see is Medicaid planning. So people want to gift away their home to avoid Medicaid payback rules if they're going to go into nursing
care. You and Andy
care.
Need to talk after the show.
Yeah, and so this is a common one. People think, I give away my home, I can avoid Medicaid payback requirements, and I can qualify for Medicaid. Big issue is there's a 5-year look-back period. You give away your home to your children to avoid these Medicaid payback rules, you may be disqualified for a long time because of the gift you made. Even worse, in some situations, the state will actually pursue an elder abuse claim against your children for these gifts if you later try to go onto Medicaid and they don't help you out at that point. So it's a pretty risky maneuver to transfer a home to avoid Medicaid payback requirements.
Got it. So if you're out there and you need any assistance in estate planning and really finding out what you should be doing to make sure that you're not making a big financial mistake for yourself and for the family that you're leaving behind, give the show a call, 1-855-400-1150, and I can connect you with Anton. Or Anton, how can they reach you directly?
You can reach me directly by calling Rehberg Law Group at 206-246-8772.
Anton, thank you so much for coming back into studio. It's always a pleasure to interview. Appreciate it.
Yeah, thanks for having me.
And coming up next on the Money Hour, zombie Social Security. What is it? Andy Landis, nationally known author and speaker, right here at 1150 a.m. at KKNW after the short break.